Hello, ladies and gentlemen. I am Professor Carrier, Western Michigan University, Thomas M. Cooley Law School. I'd like today to make some pointers or give some hints or highlights with regard to Class 2 of Contracts 1. And it begins with the concept of what happens when there is an acceptance. If there's an acceptance, the rights and duties of the parties are locked in and it changes. Secondly, I'd like to cover the concept of knowledge of an offer. Because the offeree would need to know that an offer has been made before he or she could accept. There are some newfangled ways of accepting, which are necessitated by changes in how business works and society functions. I'd like to explain that at least briefly. There are different ways or modes by which an offeree can accept. You can accept by a promise. You can accept by performance. And so that is an important part of today's material. There's a special trick in one of the cases where you are watching or reading and thinking offer, acceptance, and you will see that something that looks like an offer is not. It is actually a request that the other side makes the offer. So the person who makes the first statement is actually becoming the offeree. And that's a tricky part to one of the cases, understanding of which will help you make it clear. There are some circumstances for acceptance and how acceptance can be done. It has to be reasonable under the circumstances and responsive. We'll talk about that. This includes silence. There are certain cases where somebody may accept an offer by silence, but you have to look for particular facts or circumstances for that to be the case. Question of knowing about the offer and also motive for accepting an offer are also at issue in today's material. So moving to same, I'd like to highlight three particular, let's call them elements of an acceptance. First, you have to have a clear intent to accept. Not, let me think about it. Can I talk to my wife first? It has to be, I agree, I accept, here's the money, where do I send the check? Second element, your acceptance to an offer needs to be communicated. You can call on the phone, I accept. You can yell when you're in person, I accept. You can send a letter in the mail, I accept. If that is reasonable under the circumstances. An email might work, but there are various, even performance. Don't tell me whether you accept or not. Just begin painting my garage. The beginning of painting of the garage, if it's beyond preliminary steps and goes significantly into the service, that would be an acceptance under the common law. Also, and I want to be careful about this, the acceptance needs to be responsive. Now what I mean by that as an example is, if someone offers you a motorcycle for $10,000 and you write back and say, here's the $5,000, that is not responsive because it changes too much of what the offeror expected the offeree to do in return. And with regard to responsiveness, there's an old rule called the mirror image rule, which is not necessarily dead, but it is no longer the most important, it's no longer the standard, because we look for something responsive, if not exact, with regard to the acceptance. I'll explain that in a little bit. Going to some of the case highlights. The most important facet, probably, of the first case, Cartoon Monahan, is that the offeree is not bound to an acceptance if he or she does not know what the terms are. And so what we have there is we have a hidden term by the offeror in very tiny print that no one reads without any indication that the offeree knew that this amendment to the contract was going to happen. And although the person continued to use the credit card after this change had been proposed, the person was unlikely to have read about it, unlikely to have understood it, and yet it was a very important change in her rights. And so the fact that she did not know about it was an indication that she probably did not accept those terms. You cannot accept terms that you are unable to know or you are unable to understand. In Pro CD, that is a new form of acceptance. The problem in that case involves the purchase of a box containing certain software. And the terms and conditions of the software are so complicated, and that's something you see in today's world, that you simply cannot ask somebody at the cash register to read everything and check an acceptance. So just paying is not necessarily an acceptance. What happened in that case was that these terms and conditions were in shrink wrap inside the box. Box was not able to be opened prior to the purchase. But the acceptance wasn't at the exact moment of purchase. It was in fact after the opening of the box and after having had the opportunity to read the terms and conditions on the shrink wrap or within the box that was shrink wrapped, and having the chance to toggle on the internet, I agree or I disagree. And it's at that moment, I agree, where there's acceptance. And therefore, the purchase was not the operative moment for acceptance. It was the purchase and then the chance to toggle. And if the person disagreed, he or she could send it back. And sending it back is not an acceptance. With regard to the Beard Implement Company case involving the purchase of farm equipment, there's an interesting trick there that catches many people by surprise until they understand how it works. In that case, the sales company was not the offeror saying, I offer to sell you X. That company said, basically, I ask you, buyer, to send me your terms and conditions in an offer to purchase. And so you send me, I'm not sending you the offer, I'm asking you to send me the offer. And when I see the offer, I can choose yes or no. But I am not bound until I accept. And so the trick is that the person that you think is the offeror, which is this company, is actually the offeree. And the request is that the buyer becomes the offeror putting in a bid. And that's a very interesting distinction. If that's not well understood, that case becomes very, very difficult to comprehend. We have the Fujimoto case. And in Fujimoto, one of the primary issues is whether or not certain activities of the offerees to a service contract constituted an acceptance or not. And the services or the activities undertaken by the offerees were their continued employment and working on a particular project. And so the offeror demanded that the offerees had to sign the contracts in writing and mail back, and the offerees argued, you did not specifically require a signed return of the contract. And rather than do that, we continued to work and we continued to manage, which was good enough as an acceptance. In Day versus Caton, we learned that even silence can constitute acceptance under appropriate circumstances. It can't be in any particular case, but, for example, if an offeror writes and says, we're friends, I want to sell you my motorcycle, I know that you want to buy it, I know that you have lots of disposable cash, I know that you don't want me to sell the bike to anyone else, and therefore, and since you're traveling, but I'm sending you this email, if you do not respond to me in 3 weeks, I will take that as your agreement to this deal, and you will have accepted it that way. And under certain circumstances, that is fine. And the party, if he or she does not want to be bound, can jump up and say, stop, I don't want that, I don't want the deal. But if he or she knows of the deal and says nothing, why should that not constitute an acceptance? Finally, we get to Davis, and the Davis case identifies two different modes, primary modes of acceptance. You might have a bilateral contract, which starts with a promise. I promise to sell my motorcycle. And it requests a return promise. If you promise me that you will pay me $1,000 a month for the next 3 years. And what you see is a promise for a promise. And so if the offeree mails $1,000 in the first month, that is not an appropriate acceptance. This person asked for a promise to pay the entire amount in $1,000 installments. That is how this person must accept. And that, in fact, is, well, I'll hold that. I'm going to talk about the mirror image rule in just a second. Sometimes performance is expected or is fine as a way of accepting an offer. If you paint my garage, I'll pay you $2,000. I didn't ask the painter to promise me. I asked the painter to paint my garage. And so if the painter walks up one day with paint cans and ladders and all the tape and begins to do the painting, that should be good enough as an acceptance. And the offeror would not be allowed to say, wait a second, I needed your promise, not your performance. And so it does depend on the facts and circumstances and what the offeror demands. However, if the offeror is not clear, typically the offeree can accept in any mechanism or by any means reasonable. And so a promise that's conveyed is enough. The actual beginning of performance should also be sufficient. Let me talk a little bit about the old common law. In the old days, when contract law was significantly more conservative, there was this concept of the mirror image rule. And what that provided was that an acceptance by an offeree had to be exactly in the form of the offer, with no differences or no changes. Any difference, any change, like delivery Wednesday instead of Friday, would be a breach of or change of or a problem under the mirror image rule, and it would constitute not an acceptance but a counteroffer. The law has realized that that is not really a very practical law in today's world, and so now the society and law have both moved away from the mirror image rule and have focused upon a reasonableness with regard to acceptance. And so, if the offeror needed the things by Friday, and the offeree writes back and says, Friday, but late afternoon because the morning's not possible. The words are different. Friday versus later in the afternoon because Friday morning's not possible. Under the mirror image rule, that would be a rejection counteroffer. But that just doesn't make sense in today's world, unless the offer is clear. I need it by Friday morning or no deal. Then the offeree has to answer, I will get it to you by Friday morning as you request. If it's Friday only and he says Friday night because, then under the rules and the way the law works today and the way that society is working, that would still be an acceptance, even though there are some slightly different terms. They are not a significant deal breaker. And so keep in mind that in the old days, in the past, the mirror image rule was in full force and effect. But society in general, the courts, the laws, we've tried to move away from mirror image and to accept something much more reasonable. Let me recap. As we go through the cases, you'll learn certain specifics. You'll learn about bilateral contracts versus unilateral contracts and how they may be accepted. You'll learn next week about the mirror image rule, which is a form of acceptance when acceptance takes effect. If you mail an acceptance, put that in the mailbox. We'll learn about that. But one thing that I'd like to leave you with now is the basic elements, if you will, of an acceptance. The acceptance needs to be knowing and voluntary. The offeree needs to know what's going on and to accept the basic terms of the offer. And if he or she doesn't, then it's not an acceptance. Secondly, the acceptance needs to be communicated. You can't think in your mind that you're accepting the purchase of that motorcycle. You need to call, you need to email, you need to mail, you need to communicate that you have in fact accepted it. Because until you've done that, the offeror might have the ability to revoke his offer or her offer and sell that product or perform with another party. Finally, and this is where the mirror image rule in the old days came in, the acceptance needs to be responsive. In the old days, under the mirror image rule, the acceptance had to track exactly what the offer said. Today, we like to say that unless the offeror specifically requires it, then responsiveness with most of the major terms and agreement on most things is good enough. And so we say responsive rather than exactly the same as the offer requested. If the offer is clear, then the acceptance has to be that way. if the offer requires the acceptance to be just as the offer was written. But typically there is more wiggle room, and so if it's like a hand grenade, if the acceptance is close enough to do damage, to accept the basic major terms of the offer, then it probably is responsive and we have an agreement formed. Going back to why that's important, once the offer has been accepted, now we have binding rights and duties of the parties measured from that moment. Thank you, and I look forward to seeing you on Monday.